Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to discuss with you what are the differences between a will and a trust. Now, both these documents are ways in which we transfer assets to our loved ones after our passing. The biggest difference between the two documents is that a will is actually a court document. It is a document that goes through the probate process and tells probate court who to give your money to, who to give your assets to after you've passed. Whereas a trust is a contract that actually exists during your lifetime between you and the trustee, the person who you select to be the trustee. And in that contract, you set out the rules by which the trustee will manage your assets during your lifetime, how the assets can be spent, and then who to give the assets to after your passing, and how they can give those assets to them after your passing. So in a will doesn't actually have any effect until you actually pass away. So with a will, you can tear it up, change it, do whatever you want. You can have 15 versions of a will. The only version that matters is the very last one that is properly executed. Now, to be properly executed, a will has to be attested to by the signor, who has to be over 18 years of age and competent mentally. Then it has to be witnessed by 2 witnesses. And we recommend that it also be notarized. If it's notarized, then the court will automatically accept the witnesses as having been witness to the signing of the will, and the will is what we call, the notary will act as a self-proving affidavit, which means that the witnesses won't be required to come in and testify that yes, they actually witnessed you sign this will and that they were present for it. The fact that a notary signature is there along with their stamp is accepted by the court as the witnesses' signatures are true. So there's no need for witness testimony. Now, once the will is submitted to the court will read the will, and then the person named as the executor in the will be charged with the duties of actually executing the will, the requirements of the will. That's why they're called the executor. They actually execute what's laid out in the will. Now, the will be read and attached to now the will becomes a public record. The probate court is actually an open court. It is a public court. Everything that is done in there gets published and is available to the public. Whereas a trust is a private document. Trusts are contracts between you and the trustee, typically yourself as the first trustee, where you lay out the requirements by which the trust will distribute those assets to your children and how. So a trust remains completely private between you, your attorney who handles the trust, and the trustee. It is not a public record, does not have to be published as part of probate. That trusts are typically cheaper to administer than a will, whereas a will, it's set by the legislature, what the cost of probate is, which is typically between 4 and 5%. Usually a trust can be administered for about 3%. So you're saving thousands of dollars when you're talking about the value of an estate. One of the most important differences between a will and a trust is when you inherit money through a will, there are no protections on that. That money is now yours. You own it, and if you have creditors, they can seize that money or they can try to garnish that money. However, if you receive money through a trust, the trustee has the right to hold on to that money and distribute it to you as set out in the trust. Typically, when a trust is set up, you give discretion to your trustee when and how they make those disbursements to the beneficiaries. So if a beneficiary has a lot of creditors, say they had credit card problems, they went through a divorce, had medical issues, or perhaps they started a business that failed and they got creditors with serious judgments against them. If they inherit money through a will, then creditors will find out about it typically, and they'll be able to garnish that money. It won't be able to be protected. However, because they inherited that money through a trust, the trustee is actually the one in charge of the money, and it's only in their discretion where they get to give the money to the beneficiary. So if a creditor cannot attach to the trust or try to collect any money from the trust, they don't have the right to do so because the beneficiary doesn't have a right to that money until the trustee actually gives it to them. So it's a way for your children to be able to have access to the money without actually losing that protection and exposing that money to their creditors. One of my favorite parts about a trust, however, though, is that you get to maintain control of your money and your assets from the grave. You can pull those strings from the grave. In fact, there's one client that I previously had where the father required that in order for the children to receive their check each year from the trustee, they had to show up at their mother's grave on her birthday and bring her flowers for her birthday. Now, although the father was long since gone, he made sure that his children saw their mother on her birthday, even though she had previously passed, that they showed up at her gravesite and they put flowers on her grave on her birthday. And if they didn't get their money for that year from the trust. So the trustee would go and he'd be there from 9 until 4 during the day. He'd pull out his chair, read his newspaper, eat his lunch. But he made sure that if they weren't there during that time to deliver flowers for the mother's grave, they didn't get the money. Needless to say, the children remembered their mother's birthday every year. The mother had flowers on the grave, and they actually were kind of forced to spend time with their mom, but they spent time with their mom each and every year. That's one of those things that you can control through a trust that you could never possibly do through a will. If you have any other questions about the difference between wills and trusts, we'd be happy to discuss them with you. Just reach out to the Johnson Law Firm and we'll answer those questions for you right away.